Greetings and salutations, all of my fellow American sovereigns. This is the Vocational Science Freedom Saturday Night Civics and Sovereignty class. And tonight we will be continuing our reading of Institutes of American Law by John Bouvier. And this was a large set of books that was written in 1854, prior to the Civil War and what happened during Reconstruction, which was quite a bit. And I also put into the mega file, which is linked in the show notes for everyone, Bouvier's Law Dictionary of 1856, and the second version of this massive work in 1870, because obviously they had to change quite a few things after Reconstruction. And if anybody notices, the original 54 version is 4 volumes, and the 1870 is only 2. So they took out quite a bit between the two of them. But the link is, as I said, in the show notes. And if any of you are new to using Mega, if you click on a Mega link and it asks you for a key, make sure you put in all of the numbers and digits and symbols that are after the number symbol, meaning like the little tic-tac-toe symbol. And then you'll be able to download what's in the files. Okay, we left off, I believe, on page 150. No, I think it was 148. Okay, so let's get down to page 148. And it was, we were dealing with persons. So the chapter started, book 1 of persons, part 1 of natural and artificial persons. And persons are divided into natural and artificial, and these will be considered separately. And we got through a little bit of that down to chapter 4. Classifications of persons, section 1. So we have public persons. So in the United States, public persons have but few privileges more than private citizens. These are granted to them, not for their own advantage, but for the public good. As, for example, a congressman cannot be arrested nor sued in a civil case while attending his duty in Congress because the public interest requires his undivided attention there. Now, to make a point about that, or to just bring something up that it always has somewhat bothered me, when the Constitution was set up, I do not believe in any way, shape, or form that the Founding Fathers ever thought that Congress would be in session for the entirety of a year. That was not their intention, and I'm quite certain that they never thought that would probably end up happening. So consequently, what ends up happening is that, well, congressmen are always exempt from cases. Well, great. I'm sure that wasn't their intention, but that's what it's turned into, is having these people being immune from civil cases pretty much for the entirety of Congress. But to continue, public persons are magistrates of various grades, from the President of the United States down to constable. Section 2 of private persons. All persons who do not fit official stations are private persons. These will be considered in separate classes. Now, the other thing I want to mention about the use of the word person in this book, okay, is going to differ from the definition of person in, say, statutes, acts, ordinances, or codes, whether it be state or federal. And when it comes to federal statutes, I always make the point, and I will bring it up now just so everybody can see it again, even though I've said this multiple times over multiple years. In the United States Code, the definition of person is here. It's 1 U.S.C. subsection 8, person, human being, child, and individual, as including born alive infant. A, in determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the words person, human being, child, and individual shall include every infant member of the species Homo sapiens who is born alive at any stage of development. So under the entire United States Code, for any act of Congress, a person is an infant. Period. Full stop. All Congress is doing is administering abandoned infant estates. And that is the proof thereof. Okay, back to the reading. 151. The physical difference between male and female animals are called sex. In the human species, the male is called man and the female woman. The first difference which nature has established among persons is that of the sexes. And I'm going to skip some of the Latin in here. One, because I'm not always exactly sure how to pronounce it. I mean, I've read a lot of Latin in my life, but I'm not classically trained, so I will probably be skipping a lot of it. Just saying. Some human beings whose sexual organs are somewhat imperfect have acquired the name hermaphrodites and are adjudged to belong to the sex which prevails. The condition of woman is, in many respects, less advantageous than that of man. Sorry, girls. This difference is owing to part of nature and partly to our customs and to the positive institutions of society. Let us examine the question between husband and wife. By the natural law, the superior control in state of marriage belongs to the man rather than the woman. Perfect equality is impossible, and as the marriage is a partnership between two persons, one must have the controlling voice when both cannot agree. The preponderating voice belongs to the husband rather than to the wife. He is stronger and more courageous. He works to support the family of which he is the head and which he is bound to protect and defend. Woman must then yield to him, whom nature and the laws have provided for her as a guide and protector. Now, that whole paragraph would, I'm sure, send every single liberal lunatic absolutely crazy. But this is the understanding of what our society was, and by the basis of the natural law, tonight, as we go through marriage and some of these other aspects of the relationships between husband and wife, you're going to see how everybody knew that this was how this was pre-Civil War, and certainly before communist influence and Roman civil law and the attorney came in to attack, certainly, the institute of marriage by getting in between the husband and the wife by inserting a third party called the state, of which is based upon the marriage contract, something of which most people do not even realize is a contract, and certainly do not realize that in entering into said contract, you are agreeing to all of the shitcanery which goes along with what it says in the quote unquote statutes that you have to do based upon being a person, as I said before, is defined differently, and they see you as infants, so that the state can come in as a third party. And also, when it comes to divorce, then also determine who gets what because they are part of that contract. And on top of it, because of that contract, the production between male and female are children. So that's one of the first ways that, unless you want to consider the actual birth certificate contract and the registry of the biological property itself, that marriage contract is where the state gets its claws into you and the family and the ability to say, I don't know, send CPS around and say, you don't get to have your children anymore because, I don't know, you want to homeschool them or something crazy like that. Well, what comes first, the chicken or the egg in that situation, as far as law is concerned, is not really even an argument to bring up. The fact is that they're both situations wherein the state is now fully in your business, and it's done by the contracts of which you consented to. But to continue. All right. So this is the source of the prerogatives which the husband has over the wife. Hence it follows that the wife cannot make any contracts binding upon herself without the express or implied authority of her husband, nor make a will, the existence of a married woman being merged by a fiction of law in the being of her husband. So isn't that interesting that at this time in American jurisprudence, that the woman could not make a contract without the express or implied authority of her husband? Does that make sense? Yeah, it kind of does. Because if, say, some unscrupulous attorney came to a wife and said, here, we should do this, right? And gets her to sign some contract of which the husband did not consent to and didn't even know of, then it was automatically seen as void ab initio. Is there wisdom in that? Yeah, it is, because then the husband always has protection over the wife of anyone who would attempt to do that. And also, the woman also can't enter into contracts with the corporate state either, which would also be a very good level and shield and wall of protection for the female. So anyway, as much as some people might yell and scream about that, I do see some wisdom in it. Okay, 153. Single women, when of full age, notice that, have all the civil rights of men. They may, therefore, enter into contracts and engagements, make wills, sue and be sued, be trustees or guardians. They may be witnesses, and for that purpose, they may attest all papers. Among the civilians, okay, now people might not understand, even have any idea what that means. Okay, so when it says among the civilians, so civilians is the aspect of, it was called something else longer past. They were called civilists. It was those that were of the learned aspect of Roman civil law. Because wherever you see the word civil, like civil law, it's in reference to Roman civil law, okay? So there are two major different types of law that have pretty much evolved throughout history on this planet. Roman civil law and common law. And then there's two origins of law, which is either common law or statute. So when it says among the civilians, that's what they're speaking of, those that are focusing on the Roman civil law side of things. All right. So among the civilians, they may dispose of their property and make contracts like men, but they cannot be guardians nor attesting witnesses. In general, women possess no political power. They cannot hold office nor vote for officers. Now, clearly, this is prior to the amendment of which made women capable of voting. Instances occur, however, for their being appointed postmistress. Of the difference between persons with regard to age, the prerogatives granted to age take their rise in the law of nature. Nothing is better calculated to support public morals than perfect subordination of the youth to the aged, meaning respect your elders. And respect your parents. The want of proper regard and deference to old age has been considered as one of the most strongly marked features of deprivation. But as it cannot be ascertained when each individual has been so far developed as to act for himself, the law has fixed an age at which all who attain it are presumed, again by presumption, to have their proper faculties. The time fixed by law, then, establishes a legal presumption of legal capacity. And this is where you're getting into, and from the common law side of it, when you go and read the Magna Carta, Zenalaw made me giggle there. From the standpoint of the common law, it goes back to the Magna Carta in Article 3, 4, and 5, where it states that when the heir comes of full age, he shall have his estate without fine and without fee. Because back then, the barons were rather mad at the king, who was taking a tax from everybody who was going to take their estate, meaning if you were the, say, son of an earl or son of a baron, or even son of a knight, whatnot, and you were going to get that estate and then have title to it, the king was forcing everybody to pay quite a bit of money, and the barons had absolutely enough of that shit. So they said in the Magna Carta what I just said. When the heir comes of full age, he shall have his estate without fine and without fee. So as we saw in the previous page, where it says here, single woman, when of full age, this term right there, comes of full age or being of full age, that goes all the way back to the Magna Carta, okay, to 1215 AD. That's the common law. Okay, to continue. Article 1, as to males. Before arriving at 14 years, a male is said not to be of discretion. By the common law, at that age, he may consent to marriage and choose a guardian. At 21, he is of full age for all private purposes, and he may then exercise his rights as a citizen. by voting for public officers and being a citizen, he is eligible to all offices unless otherwise provided for in the Constitution. Now, make a point here. The use of the word citizen in this paragraph is not a citizen of the United States under the 14th Amendment and subject to the jurisdiction thereof. This definition of citizen here in this paragraph is in regard to a de jure state citizen, i.e., one of the people of the several states of the American Union who, at this time, had to be white. So that's what that definition means as it's stated in that paragraph. Okay. Article 2, as to females. At 12, a woman arrives at years of discretion and may consent to marriage. At 14, she may choose a guardian. And at 21, as in the case of males, she is of full age and may exercise all the rights which are inherent to her sex. So, as you see back then, people would get married at a much younger age, mostly because, one, people didn't live as long. Two, the institute of marriage at those ages was quite normal. Case in point, the first admiral of the United States Navy, his name was Farragut. And as I recall, he was 13 years old. So 13 or 14. So when you have someone of that young of age managing literally the life or death situations of potentially thousands of men, it would not have back then seemed odd that someone that had that amount of responsibility and control over, say, naval forces would not be able to marry, right? It would seem rather ridiculous. So in that sense, that's what it was. But the age of 21 is interesting because I'm going to bring my USC paper back up because there's something I found in USC that I thought was very odd. And it was from a standpoint of this aspect of presumption. So part 1, nationality at birth and collective naturalization. So this is 8 USC subsection 1401, nationals and citizens of the United States at birth. You come down here and you look at this and it says F. And wait, let me read the top part so you have some context. The following shall be nationals and citizens of the United States at birth. F. A person of unknown parentage found in the United States while under the age of 5 years until shown prior to his age of attaining 21 years not to have been born in the United States. Now, from a standpoint of us reading this, the aspect of United States is the District of Columbia and all the possessions thereof of the creature that was created in 1871 by the District of Columbia Act, aka USA Incorporated. So what they're doing here is they're creating a presumption to stick you underneath the jurisdiction of the District of Columbia, prior to his age of attaining 21 years. So basically, if you do not rebut the presumption before 21 years of age, and I've had this debate with people, like they said, well, then once you get past 21, you can't undo it. I'm like, no, because it's all done by fraud. And furthermore, you're sovereign and you have your own will and you can exercise your will when you see fit. And on top of it, there are everything from international treaties to maxims of law, which state that a man always has the right to determine his own, I was about to say citizenship, but in a broader sense, his civil relationship, or any civil relationship, I should put it that way, that he wishes to or does not wish to, meaning he has the right of association, right? I don't want to associate with you, or I do with you over here and not you, or whatever. His own destiny. Yeah, good point. More or less that. So there's nothing that a statute, act, ordinance, or code can bind you into from a standpoint of you losing your sovereignty by presumption. And there's more reasons for that. One of them is that the maxim of law, which states that the rights of blood and kinship cannot be destroyed by any civil law, meaning Roman civil law. And the fact that because of that, from the aspect of consanguinity and the fact that we are members of the posterity, meaning the heirs that come after, those that ordained and established the constitutions, both state and federal, we as the people therein retain that same sovereignty to us as they had. by taking it from the king in war. Because there's only two ways that you become a sovereign, either by sanguinity, as I said, or by war. That's it. There's no other way to get it. So I just want to show you guys that as some of the chicanery that attorneys try to do to create these presumptions and hope that you don't find out what they're doing and then rebut them. Otherwise, if you just go along with it, they're going to bind you to whatever presumptions that you're not paying attention to, basically by your own consent or by your silence, because silence is consent in Roman civil law. As ridiculous as that is, that's just part and parcel of it. Okay. So another good reason why you always want to object whenever the judge says something in court that you don't like. Even if you don't have a good reason, just object. Because if you don't, you agree. All right, so on to the next one. Of husband and wife and parent and child. The third difference between persons is that which results from the relations established between husband and wife and parent and child. This subject will be considered in another place. Of citizens and aliens. The fifth difference between persons exists between citizens and aliens. These will be separately considered. Article 1 of citizens. A citizen of the United States, and again, this term here, a citizen, lowercase c citizen of the United States. This is one of the people of the several states of the American Union. This is not, under any circumstances, someone who is subject to the jurisdiction of Congress, which was the 14th Amendment ruse to, under the aspect that, we should give all of the newly freed slaves, quote unquote, civil rights, even though, strangely enough, I have found in congressional record that during debates of the 14th Amendment in Congress back then, that even Congress agreed that you couldn't do that, meaning like you couldn't just give a whole status of people an aspect of the rights or to turn them into citizens, meaning de jure state citizens. And it clearly said that in the arguments in Congress in the congressional record. Now, I didn't put that into the show notes, but I do have it, and you can find it. And maybe I'll dig it up and try and, if somebody wants to make a point to remind me after class, and I'll go grab it and put it in here. I'm pretty sure it's in my 14th Amendment file. Okay, so anyway, citizen, we're talking about state citizens here, and I really like this definition, is one who is in the enjoyment of all the rights to which the people are entitled and bound to fulfill the duties to which they are subject. This includes men, women, and children. Period. Now, to me, that's a pretty good definition of a de jure state citizen. Now, could we take this and actually take this out of the Institutes of American Law and say, put it into a court case and say, this is, authority? Well, no, not really. But we don't need to, because it's stated in other locations. But I just thought this was a really good and correct way to very succinctly in short verbiage state what an actual de jure citizen is. A citizen of the United States is one who is in the enjoyment of all the rights to which the people are entitled. And guess what? That means everything to which your will determines. Just because there are certain rights and certain things, I should say certain powers, which are vested to this thing called government, even from the standpoint of the original constitutional republic, just because a right is vested does not mean you lose it. And as it clearly states in the 9th and 10th Amendments, that all powers not vested to the government are retained by the people. So what is that? What is that list? It's literally anything that you want to do, as long as you're not causing damage, harm, loss, or injury to somebody else or their property. That's it. That's the only restriction. So when you talk about all, it's really whatever you come up with. Okay. You want to say it's your right to walk back and forth across, your lawn 1,000 times a day. Great. That's your right. It's your right to plant trees on your property. That's your right, because it is your land, supposedly. But sorry, I don't want to digress into land rights. This will get into land rights later, so I'll leave it for that. All right, to continue. In a more limited sense, a citizen is one who has a right to vote for public officers, for example, representatives in Congress, and who is qualified to fill offices in the gift of the people. Right? Because those in government, it's a gift for good behavior. And if you're not in good behavior, we can get rid of you with the grand jury. But to continue, citizens are natives or naturalized. All persons born in the United States are not citizens. The exceptions are, first, children of foreign ambassadors, secondly, Indians, and thirdly, in general, persons of color. So, as it says right there, and as the arguments were stated in the 14th Amendment in the congressional record, persons of color are not citizens of the United States, meaning de jure state citizens, meaning we the people. Okay? They can be citizens of the United States under the 14th Amendment from a standpoint that they're subject to the jurisdiction of Congress. Yes. But that's all the farther they can ever go. Because what happened after the Civil War was that they went from being private property to literally being public property. And if anybody wants to crucify me about that, I don't give a flying fuck. It's what happened in the law. I'm not making this up. I'm not saying it out of spite one way or the other. It's what is written. So, just saying. All right, 161. A naturalized citizen is one who, born an alien, has acquired the right of a citizen by complying with the requisition of the naturalization laws. Also, at this point in time, regarding naturalization laws, it was only white people of good character. The principle of which are the applicant shall be an alien and a free white person. Okay, I just reiterated it right there. 2, that he shall have declared before some competent tribunal, an oath or affirmation, 3 years at least before his admission, that it was bona fide his intention to become a citizen of the United States. Now, I find this odd that in this sentence, they capitalized C citizen here, and they didn't up here. Instead, they put it in italics. Now, there's a court case here, both of which seem to be the same case, but they're just referring to it twice. So in the A part up here, this is Amy versus Smith, and I'm going to read this because it's probably too small for you guys to see. Persons of color and Indians have some rights as citizens. They cannot in any sense be considered as aliens, nor can they be deprived of any of those rights which belong to American citizens, of holding property, of obtaining a patent for an invention, and the like. But they are deprived in some states the right of voting for public offices or of holding offices. Okay, so that's of the dependence of where it was at that time, right? And the states were different based on the different laws. But as it said here, from the aspect of the nationality side of it, that the applicant shall be an alien and a free white person. That is stated, I know, at least 4 different, well, maybe even 5 different times in the law, from Naturalization Acts, from the original one all the way through until the fuckery happened in and from the Jews that did what they did regarding, hey, let's let the floodgates open and let anybody in here. And that's when they changed it. And of course, we know that's because part and parcel of the clergy plan and whatnot. But I won't get into the rest of that. All the rest of you who know, and those of you that don't, just go do some research. All right, to continue. To renounce forever all allegiance and fidelity to every foreign prince and principality. But that's the and etc. part, because that's the part of the original 13th Amendment, not the second 13th Amendment that supposedly freed the slaves, but the original 13th Amendment, which was actually passed and ratified, which is verbatim one of the Articles of Confederation, which stated that if you held, and I'm going to just paraphrase it because I don't have it in front of me, but basically it said, if you hold allegiance to a foreign prince or principality, you may not hold office in the United States of America. Now that meant any office, county clerk, bailiff, whatever, didn't matter, mayor, all the way up to the president of the United States. So who are those that hold allegiance to foreign prince and principalities? Those with titles from said people, right? Like a knight of the realm, meaning from England, would be disqualified from holding office in the United States of America under the 13th Amendment. And guess what? Also would be esquires, because an esquire is one title below a knight. So all these fucking attorneys out here that have a title of esquire cannot, by law, under the Constitution and ratified original 13th Amendment, hold any office in the United States of America. So technically, are they violating that? Strangely enough, no, because they all work for a corporation. They're not holding offices from the original republic, because the original republic offices have basically all been vacated, for the exception of those that have done certain things to supposedly reclaim them. But so that's a little history about the 13th Amendment and that little etc. part after the foreign prince right there. So just thought I'd give some context. All right. And particularly by name, the prince, etc., whereof such alien may at the time be a citizen or subject. But if such applicant has resided and continued to reside in the United States between the 14th day of April 1802 and the 18th of June 1812, he may be admitted without making a previous declaration. Number 3, that at the time he shall be admitted by the said tribunal to become a citizen of the United States, he shall so renounce such allegiance, meaning whatever the hell he was allegiance to prior to, you have to renounce it specifically. And that's still done to this day, even if you come here and you go through proper naturalization process. There is an oath that you have to take, and there is a renunciation of allegiance, which you also have to do. Now, strange as that sounds, from the standpoint that there are still things like dual citizenship, is that actually following law? And the answer is no. So, all these congressmen out here that have dual citizenship with Israel, well, who do you really think they have allegiance to? Certainly not the United States, and certainly not we the people. It is, of course, allegiance to Israel. So, do they have the right to hold office? Again, no. But are they holding office? Again, no. So it's very odd that this whole thing is going on, and yet nobody seems to bother to pay attention to what is going on, and that everybody's being administered by a corporation pretending to be a de jure government. Boris asked me in FTJ if I want a copy of Echoes from the Cabinet. I've never heard of that book, or if it's a paper. Yeah, if you want to send it to me, that'd be fine. And if anybody wants to send me anything, you can find me at VSOF@protonmail.com. You can email me anything that you think I should check out or that I should possibly do a class on. And I also suggest, obviously, that everybody actually come and join the VSOF. It's completely free. Just go to vocationalscienceoffreedom.org and click on the welcome package to come and join us. Then you can just throw it to me in Mega, and you can just drag and drop. And that's why we use Mega, because it's very easy to do that sort of thing and share files with each other and all that good stuff. All right, to continue. Number 4, that said alien shall have resided at least 5 years within the United States and in such state or territory where such court is held 1 year at least. By subsequent acts, provisions are made in favor of persons who have arrived in the United States at different periods. Number 5, that the applicant is a man of good moral character, attached to the principles of the Constitution of the United States, and well disposed to the good order and happiness of the same. Okay. Do you think anybody that comes over here from, I don't know, the shipment of Soros NGOs has any of that within them? No, decidedly not. 6, that he shall renounce all titles of nobility to which he may be entitled. 7, that the native country of such alien is then at peace with the United States. And there are 2 classes of persons who, though born out of the United States, are nevertheless citizens thereof. To the first class belong children of American ambassadors born abroad. Among the second class are, quote, the children of persons duly naturalized under any laws of the United States, or who, previous to the passing of any laws that subject by the government of the United States, may have become citizens of any one of the said states under the laws thereof, being under the age of 21 years the time of their parents being so naturalized or admitted to the rights of citizenship, shall, if dwelling in the United States, be considered as citizens of the United States. Okay, that was a very long sentence, but I wanted to back up here to what this just said. I kind of blew past it, and probably most people didn't even realize what I said. Okay, may have become citizens of any one of the said states under the laws thereof. What does that mean? It means that there are laws, and I've seen California's, in individual states that allow you to then become a citizen of that state as per statutes that were laid down under state law. Like I said, I've seen California's. I'd like to find other ones. I think somebody mentioned that Texas also had them back in their creation days, which would make sense because Texas was technically its own nation prior to joining the Union anyway. But I'm sure there are more. So from that, you think, okay, if there was actually laws on the books in the states that said that you could join them as a state citizen, then my musings would be, then why on earth could we not still do that? Because unless they have actually repealed the law itself, then one could still go through the process. Now, they may not like it, but if it's the law, they have to follow it. And you could sue them if they didn't. So I'm just saying, even though we declare this to be what our status is in the vocational science of freedom status documents, of which we then record onto the public record and then process serve them as per the Expatriation Act and all other acts of Congress. Oh, one of which I will also bring up again and make a note of here because I thought it would be good to read it. The fact of the changing of the status, okay, and the reason why we do what we do and we make sure that it's on public record and then we process serve them is basically because of this United States Code. So 5 USC 552AE, access to records. Each agency that maintains a system of records shall, and whenever you use shall in statutory construction, it's absolute. 1, may request by any individual to gain access to his record or to any information pertaining to him which is contained in the system. And this is the interesting part. Permit him, and upon his request, a person of his own choosing to accompany him, to review the record and have a copy made of all or any portion thereof in a form comprehensible to him, except that the agency may require the individual to furnish a written statement authorizing discussion of that individual's record in the accompanying person's presence. Okay. I just want to tell you guys, this is part and parcel of FOIA, what I'm reading from. Because FOIA is kind of like scattered all over the USC, but this is a very important part of it. And then 2, permit the individual to request amendment of a record pertaining to him and not later than 10 days, excluding Saturdays, Sundays, and legal public holidays, after the date of receipt of such request, acknowledge in writing such receipt, and B, promptly either BI, make a correction of any portion thereof which the individual believes is inaccurate, which would be like, hey, you guys have me down as a citizen of the United States subject to the jurisdiction of Congress. That's not correct. I'm actually a de jure state citizen. I'm a Wisconsinite, or I'm a Texan, or I'm a Floridian. Please correct the record. Okay. Relevant, timely, or complete, or BII, inform the individual of its refusal to amend the record in accordance with his request, the reason for the refusal, the procedures established by the agency for the individual to request a review of that refusal by the head agency. This is attorney jargon of, well, if we don't want to do it, we're going to have to give you a reason why we're not going to do it. And then we'll just go through all this agency stuff not to do it. Well, tough shit. It still says that they have to give you a reason. It has to be a lawful reason. Okay. They can't just make one up. So this USC is the reason how and why we can correct the record from a standpoint of them considering us to be citizens of the United States and not to be de jure state citizens. Okay. So that's why we're doing what we're doing. So to make sure, hey, get this corrected and stop fucking around. And no, I don't want your benefits. And no, I don't want to have a social security number. And no. Anything else that goes along with having a contract with them that would put you in a position where you owe them a duty. Like all of that is gone. And that's where you want to be back to. You want to be back on top of them and have nothing to do with the little corporations, whether it be state, local, or federal, that bind you into anything that would reduce, diminish, destroy any substantive right that you would have, as I previously stated earlier. Okay, so, all right, so ambassadors, got to that. Okay, of the laws being under the age of 21 years at the time of their parents being so naturalized or admitted to the rights of citizenship, shall, if dwelling in the United States, be considered as citizens of the United States. And again, that's de jure state citizens. Provided that the right of citizenship shall not descend to persons whose fathers have never resided within the United States. Right there. That gets rid of every single anchor baby. Sorry. That's it. And that's the proper law. Okay. And I've also seen arguments in Congress about the aspect that the 14th Amendment would not allow for what they now consider to be a quote unquote anchor baby either. Right. So that's to be noted. All right. 162. The Constitution of the United States provides that, quote, the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. Close quote. This clause of the Constitution evidently refers to the privilege or capacity of taking, holding, and conveying lands lying within any state of the Union, and also of enjoying all civil rights which citizens of any state were entitled to. But it cannot be extended to give a citizen of another state a right to vote or hold office immediately on his entering the state. Meaning you can't just jump across the state lines to say between Illinois and Wisconsin and say, hi, I'm here. I now want to run for governor. All right. Article 2 of Aliens, 163. An alien is born out of the jurisdiction of the United States, subject to some foreign prince, potentate, state, or sovereignty, and who has never been naturalized under the Constitution or laws of the United States, or any of them. There must be a union of birth abroad and subjection to some other power to make an alien. For, as we have seen, a man may be born in a foreign country and still be a citizen of the United States and of no other country whatever. Meaning, if he was already a citizen of the United States and you and your wife went on vacation to France and you happened to have the baby in France, that baby would still be a citizen of the United States because you are. Okay. So the rights and duties of aliens will be properly considered where we come to treat the enjoyment of their civil rights. Of natural persons again, and this is of free men and slaves. Good evening, 14 words. 164. A free man is one who has a right to do whatever he pleases. Should be a period there. Not forbidden by law. Semicolon. One, in the possession of the civil rights enjoyed by the people generally, is not necessary that a man should have any political power to be a free man. An alien may be a free man as well as a citizen. So that's the difference between when you're talking about what is a citizen, what is a free man. A free man is just someone who is free, not a slave, not an infant, has no lawful incapacity, and is simply just free, but might be visiting another country. So that's a freeman. But he would not be a citizen thereof. Okay, so that's what they're getting at. And that's exactly what people were considered who were living in the territories prior to said territories dividing up and becoming actual states and then joining the Union. They were considered freemen of that territory. Okay. And you can read that in the, you can read it in a lot of places. It's in the Articles of Confederation, and it's also in the Northwest Ordinance. The use of the word freemen is in there, I think, multiple times. All right, to continue. Although he may be liable to serve another for a period of time, he is still a freeman. If such service has arisen in consequence of his agreement, as in the case of an apprentice who has bound himself to serve another for a definite period. Nor would a servant bound to serve another for a certain period be less a freeman by his liability to serve. Article 2 of Slaves, 165. A slave is one who is by law deprived of his liberty for life, and who is the property of another. Period. Okay. Property. Therein lies the totality of the situation. And again, I'm not making this up, and I'm not doing this for, any sort of raising of blood pressure in anyone. I'm just saying what the law says. So slaves are always property. So what they did was they took the slaves from being private property and made them public property because they could not take away the aspect of them being property. Okay? So one who has been kidnapped or stolen away, or a free man who has been taken by robbers and reduced to slavery, is not a slave. Now, therein lies another interesting aspect. Were not all slaves at some period of time kidnapped and stolen away and taken by robbers or some such to be taken to some other location? Answer, yes. So, strangely enough, you have one side of this and then you have the opposite side where it's like, well, then no one could ever be a slave, right? Because, okay, that's unlawful. So it's a very strange thing. It's a double-edged sword. However you want to look at it, okay, so be it. Just saying. And a citizen of the United States taken captive by barbarians and reduced to slavery does not lose either his political or civil rights on that account, of which there was quite a bit of back in those days from the standpoint of the Barbary pirates until we eventually made a treaty with them to kind of have them stop doing that. Anyway, 166. By the natural law, all men are created free, and no man can be reduced to slavery but by virtue of some law. The general government of the United States does not sanction or establish slavery. The state governments where that institution exists have authorized it by law, for without any authority, it has no existence whatever. Right, because technically slavery is against natural law. Can mankind come along and say, okay, we're going to write the statute that says you can have slaves? Technically, no. It's still a violation of natural law. The whole bloody institution was always unlawful, as it was for any group of people that ever had to suffer it at any point in time in history, including but not limited to mostly white people, because the term slave comes from the term Slav, because the Muslims took so many white Slavs as slaves that's where you get the word from. So it's even baked into the etymology. But anyway, to continue. All right, 167. It is a maxim of law that the child follows the condition of the mother. The child of a female slave is therefore a slave, whoever may have been its father. But the child of a female slave born in a free state where slavery is not recognized by law is free. So again, all this convoluted shit back and forth between what is and what isn't. And, oh, you stepped across some imaginary line and all of a sudden you're not a slave, or vice versa, whatever. I still stick with the first part from a standpoint of just simple natural law, from the standpoint that I'm a Taoist, and that the whole entire institution is and always shall be against natural law, violation thereof, and therefore void ab initio. But that's me. All right, 168. A slave has no political nor any civil rights while subject to his condition of slavery. But in a state where slavery is not allowed, a man who is a slave by the laws of his domicile may maintain an action in his own name for a personal tort committed against him within that jurisdiction. For by the law of nations, no state is bound to recognize any slavery in another state. The Constitution of the United States provides that, quote, no person held to service or labor in one state, under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered up on the claim of the party to whom such service or labor may be due. That means, in a sense, even though what is set up top, but the child of a female slave born in a free state where slavery is not recognized by law is free, well, that would seem to contradict what this says. All right, so obviously, contradiction in law is, well, it's basically a foregone conclusion. But point is that what you have to stand on is whatever provides you the highest status and the most possible expanse of rights. Basically, that's what you want to do. Okay. And in my personal belief, anything that requires any sort of violence, force or violence against you, in order for you to submit to said whatever power is obviously morally wrong and against natural law and is basically a form of slavery. Okay. So if your ideas have to be forced upon another, then they are by definition against natural law. Okay. Okay. So to continue, interpreted by the common rules of construction, by which alone it must be understood, the cause is not clear of difficulty, but as the Supreme Court has given it a judicial construction, the subject must now be considered at rest. Another important consideration has been urged since this subject has unhappily agitated our country, whether Congress possesses any power to legislate upon the subject. Right. Again, attorneys deciding what is and what is not a slave, who does or doesn't have rights. It's, again, a total violation of natural law. However, what it said was what it said. And as far as them being property, that is how it was laid out. So anyway, not going to rehash that. Just saying. To continue. From a very early period of our history, and when many of those who formed the Constitution were in the councils of the nation, a law was passed by Congress to give this clause its full operation. The Act of 12th February 1793, Section 3, was passed, and a still more stringent law was enacted by Congress in 1850 to enable the owner of a fugitive from labor to recover him when he has fled into a free state. So that was the law back then. You can go back and get them, which, strangely enough, ended up in the taking and kidnapping of blacks that were actually free in free states and then selling them back into slavery in the South. That did happen. So in some of the states, slaves are considered as chattels and some as real estate. Under the special phraseology of certain acts, they are treated as persons. Well, again, a person of a certain aspect and not of another. And I'm rather curious here in regards to what the footnotes say about the A. Okay, it is not a little singular that among the Romans there were laws not dissimilar to acts of Congress mentioned in the text. They declared a slave as a fugitive who stayed away from the house of his master with an intention of running away and escaping from his scratch. I don't know what that misprint there. The slave was not considered a fugitive who had only had the design of running away, even though he should have divulged his intention. He must have executed it. Okay, fine. After the slave became a fugitive, if anyone received him into his house in order to shelter him from the anger of his master, he became liable to an action, and the master could recover damages in an action called de servo corrupto. Corruption of the service, probably. The law treated him who concealed a fugitive slave in order to cause his evasion with much severity. True, the Romans were, the entire Roman system was, the backbone of it was slavery anyway, so wouldn't surprise me in the least that all of this would be part and parcel of Roman civil law. By a status concilium, authority was given to every military man or even an individual to enter into the lands of senators and other persons to search for fugitive slaves, and by another law, the houses of the prince himself might be examined to search for them. But in order not to infringe on the rights of individuals, the persons who made the searches were to be authorized by the president of a tribunal, who would give an injunction and send a sergeant to obtain access to the house intended to be examined. When found, the slave was to be brought before a magistrate whose duty it was to deliver him to his master if the latter's claim was established. In the provinces were arrested, the slaves were carried before the president of the province or the proconsul, who decided as the right of the supposed master. Okay. Interesting bit of history there from the standpoint of Roman civil law. Just thought I'd read that. All right, 170. I don't even know how to pronounce this. Manumission, which is an express act by the owner of a slave by which the latter is rendered free. Okay, so it's basically, he gives him his own freedom. Has the effect to change the state of the slave and then acquires all the rights of a free man of color. A slave may acquire his freedom not only with the consent of his owner, as above mentioned, but by implication or by operation of law alone, as when a master takes his slave into a free state for the purpose of continued residence. or by a continued residence there, whatever may have been his intention, beyond the time allowed by the laws of such state, the slave becomes free. He may also be manumated by the last will of his master. Right, because if the aspect of their property, then property of the res of an estate gets devolved based by will. And if no will be, then by consanguinity. Okay, subsection 6 of white and colored persons. 171. A white person is one who is of the Caucasian race, without any mixture of African or Aboriginal, or at most, not a fourth part of such blood. In the southern states, when a question as to quantity of African blood in a person arises, it is left to the jury to find it as a matter of fact. The act of Congress which authorizes the naturalization of aliens confines the description of such aliens to free white persons. And many of the state constitutions require, as one of the qualities of a citizen or elector, that he shall be white. A rule has been adopted in the slave states that color is presumption of slavery. But in the free states, this rule would probably be reversed, because there the presumption is that all men are free, and he who would rebut the presumption must establish the contrary fact. True, as I mentioned before, that was a thing that happened, wherein even free blacks in the North were literally just stolen, taken down south, and sold because of the presumption. And if you kept them quiet, or you stole them and you gagged them and whatever, and they couldn't scream or complain about it, well, that's just what happened. Number 7. Of nobles and plebeians. 172. In some countries, this distinction exists. A nobleman there is one to whom some special privilege are granted, generally at the expense of the more deserving classes of the people. A plebeian is one who belongs to the common people, also just referred to as the plebes. Happily, in this country, the order of nobles does not exist. The Constitution of the United States provides that, quote, no title of nobility shall be granted by the United States, close quote, and no state shall, quote, grant a title of nobility, close quote. All right, number 8. Now we get into the sane and insane. 173, sanity. It is the state of a person who has sound mind, one who, in his actions, conforms to those of the bulk of mankind, one whom the laws regard as capable to perform all civil duties and to be responsible for his acts. Sanity is always presumed. Wouldn't that be nice if that was still the way it was, and you didn't have all of these dark Luciferian occultist black robe priests of hell sitting up on benches using a pseudoscience called psychology to determine that everybody has some sort of condition and that you're going to be subject to the whims of that said priest of hell just because, I don't know, some Talmudic magic. You just say someone's crazy, or I don't know, maybe because I'm actually standing upon my substantive rights and are not going along with your fuckery, you have to backtrack and say, oh, he's insane. Right. Anyway, insanity is that state which includes a continued imperpetuity. I don't know how to pronounce that word. I'll have to look that one up. Impetuosity, I think, is how to pronounce that. Okay. A continued impetuosity of thought, which, for the time being, unfits a man for judging and acting in relation to the affairs of life with the composure requisite for the maintenance of social relations. One who is deprived of the use of reason after having attained the age when he ought to have had it, either in consequence of a defect of his birth or because of some accident which happened since. This state is never presumed. See, now that's the way it still should be, but anyway. But if once proved to exist, it will be presumed to have continued. The insane man is deprived of his political and civil rights. He is represented by guardian, curator, or committee. Okay. And then of infamous persons, I think I'll stop here for the night. I do want to make another point about the insanity part. So you have the insane, and then you have infamous. That's people, felonies and whatnot. But there's also another one which they'll get to, which will be also the aspect of the capacity to handle one's own affairs is not always an aspect of either you're sane or you're not, right? Because an infant is not necessarily insane, clearly, but they don't have the capacity to handle their own affairs because, as I said earlier, they have not yet come of full age. Okay. So there's those handicaps that exist in law that aren't necessarily, that from a standpoint of capacity, aren't always a mental thing. Sometimes it's just a time thing, right? As in with infancy. Okay. So I'm going to check chat here just quickly, see if there's anything anybody had any questions about one way or the other. America's Deesher, light to the nations, fake state of Israel represents Mammon and Satan. Well, yeah, got that right. No argument here. Okay. So from all of that, I'll just say one more thing to all of you. As always, if you guys would like to join the Vocational Science Freedom, you can do so by going to vocationalscienceoffreedom.org, all spelled out, and then click on the welcome package here up top on the banner, and then come down here and download it. It's a fillable PDF, and it'll tell you exactly what you need to do and to join us. And then you send your filled out welcome package to VSOF@protonmail.com, and we'll get you in. And it is totally free to do so. Costs you nothing. And for everyone who would like to help share the links for the Vocational Science Freedom, I have set up a all my links page where everybody can go and find all the links for the Vocational Science Freedom. So if you would like to share that with others and bring them in and say, hey, maybe you should check out a Saturday night class, please do so. And you guys can also find me on X now as well from that link if you ever want to chit chat or send me something on there as well. Okay. So from that, I'd like to thank all of you for coming. I will see everybody in the VSOF on Wednesday for Open Roundtable. And we may have a committee meeting possibly coming up as well. But I will tell everybody that in MegaChat when the time comes. So until that time, I hope all of you have a wonderful rest of your weekend. And as always, stay safe, stay sovereign.